Hello, everyone, and welcome to BicTok 3 Court-Annexed Mediation, When, How, and Why. Thank you for joining us in this lovely evening. My name is Sharifa. I am a senior case counsel at the Borneo International Center for Arbitration and Mediation. I understand that many of you joined last minute, or those of you joined from court. Regardless, thank you so much for joining us today. I have a few housekeeping rules. Firstly, if you have any questions throughout the session, please put them in the chat box, and then we will have them answered by the panelists and the moderator where relevant. Secondly, we also have a few upcoming events, which I will post inside the chat box. Also, the link to our social media for our future events. Without further ado, I'd like to pass to our council member, Ms. Josephine Hadikusumo, to start the session.
Good evening, everyone, ladies and gentlemen. Welcome to this session, the BicTok session on court-annexed mediation. It is my delight to introduce three very distinguished panelists for today. I think the audience members are in for a treat. But first, let me say a few words about myself and about BICAM, which is the Borneo International Center for Arbitration and Mediation. My name, as you know, is Josephine Hadikusumo. I am a mediator and a mediation trainer for the last 15 years. I did most of my mediation work as a trainer and a mediator in Singapore until my return to Malaysia in 2019. I sit on the board of the Singapore International Mediation Institute, and I'm also a council member for the Borneo International Center for Arbitration and Mediation located in Borneo. A little bit about the center. The Borneo International Center for Arbitration and Mediation, or affectionately known as BICAM, was established in 2023. And the center provides and aims to provide top-tier arbitration and mediation services for conflict resolution through the state-of-the-art hybrid conferencing technologies and an automated case management system. So our parties who come to use BICAM services are able to conduct proceedings in a hybrid format using our speech-to-text features and to schedule those hearings via automated case management system. So we aim to not only be the first center in Borneo to provide top-tier arbitration and mediation services, but we also aim to provide it at a very global level. And so this center is not old, it's very new. It started off in 2023, last year, and we welcome any kind of information or questions that you may have on BICAM. And I'm happy to answer any questions on BICAM, or Sharifa also will be available to answer questions on BICAM if you have questions on the center after this talk. Without further ado, let me move on to introduce our speakers for today. To begin with, I would like to introduce Datuk Vernon Ong Lam Kiat. Now, Datuk Vernon Ong is not a stranger to many of you. He is a former federal court judge and started private practice in 1981. In 1990, he left for Hong Kong to work for the UNHCR, and at the same time, he lectured at the University of Hong Kong and Hong Kong Polytechnic and pursued his LLM at the University of Hong Kong. In 1993, Datuk Vernon Ong returned to Malaysia and resumed legal practice, and he has served in the Kuala Lumpur and Selangor bar committees. He was a member of several bar council committees on law reform, professional development, Bahasa Malaysia, amongst others. In 2007, Datuk Vernon Ong was appointed as the Judicial Commissioner of the High Court in Malaya and sat in the Johor Bahru High Court. He was appointed as a High Court judge in 2010, eventually becoming the senior judge of the Johor High Court. And in 2013, Datuk Vernon Ong began sitting in the Shah Alam High Court. And in 2014, he was elevated to the Court of Appeal, and 2019 to the Federal Court, retiring from the bench in April 2023. So apart from his judicial duties, Datuk Vernon Ong has taken on other leadership roles, notably as Regional Council member of the Commonwealth Magistrates and Judges Association, Managing Judge for Subordinate Courts in the State of Selangor, Managing Judge for Kelantan, Terengganu, and Pahang, Chairman of Court-Annexed Mediation Committee of the Federal Court, Chairman of the Training Committee of the Judicial Academy, and member of the Judicial Academy and as adjunct professor of law at Multimedia University. So we have a very storied background for Datuk Vernon. It is also my pleasure to introduce Ms. Rajeswari. Now, Ms. Rajeswari was appointed as a chairman of the Industrial Court of Malaysia in early 2018. She was chosen as a member of the special task force that was set up by the Malaysian government to clear backlog of cases at the Industrial Court. Thereafter, Ms. Rajeswari was reappointed to the Industrial Court from 2020, in which position she served up until October 2023. In her capacity as chairman of Industrial Court, Ms. Rajeswari carried out numerous mediations and sat on various committees of the Industrial Court, such as the Consultative Committee on Industrial Law and Law Amendment and Rules Committee. She has also presented papers at the Industrial Court Chairman's Conference and at the Judicial and Legal Service Training Institute. In addition to legal professional experience in Malaysia, Ms. Rajeswari was in the unique position to join the World Bank at Washington, D.C. from 2011 as a legal advisor and consultant. And there she undertook projects on improving and streamlining labor practices, labor policies of Malaysia to be congruent with comparable economies of East Asia and Pacific region. So Ms. Rajes has got vast experience, not only in the industrial court and in mediation, but also in the international arena. And our last panelist for today is none other than Dr. Melissa Chia. She was recently conferred with a doctorate in social science on 15 December 2023, and she is a mediator accredited by the Bar Council Malaysian Mediation Center in September 2015. She is passionate in alternative dispute resolution and is a firm believer that ADR is part of the administration of justice. Known for a collaborative and empathetic approach to resolving disputes, Dr. Melissa is committed to fostering positive and constructive communication. Since 2015, Dr. Melissa actively took part in court-annexed mediations. She possesses a wealth of experience in conflict resolution and negotiation, including successfully mediating numerous disputes ranging from interpersonal conflicts such as matrimonial cases to complex business negotiations, facilitating open communications and negotiating mutually beneficial agreements between disputing parties, and conducting mediation sessions with a focus on understanding each party's perspectives and finding common ground for resolution. So as you can see, ladies and gentlemen, in our speakers today, we have got a vast store of experience, and then we welcome any questions you may have for them later on, even as they make their presentation. But let me just kick off our talk today. I wanted to say as well, audience members, if you could save your questions to the end of the session, once the speakers have had a chance to speak, I would be most appreciative. And as Sharifa has mentioned, make sure that you put your questions in the chat box, and we will curate them and we will bring them up to the speakers as you present them. Okay. Now, to kick things off, I do have a question for Melissa. Perhaps you can start the ball rolling, Dr. Melissa, by saying, what is the difference between court-annexed mediation and private mediation?
Okay, thank you, Josephine. First of all, Yang Arif, Puan, ladies and gentlemen, thank you for this opportunity. Before I go on, I must say that I'm still learning, a work in progress. So to the first question by Josephine, what is the difference between court-annexed mediation and private mediation? I have come up with three. First is the quorum. Okay, yes, we are all the same mediator, but court-annexed mediation refers to mediation where active judges and judicial officers act as mediators to litigating parties after they have filed the case in courts. Secondly, it has to be a case that is filed in court under the court-annexed mediation program. All cases must be filed in the courts before they can be registered for mediation. The only exception is the running down cases on claims for personal injuries and other damages due to road accidents, which are automatically referred to court-annexed mediation. And third is court-annexed mediation is free of charge. But however, bear in mind that parties will incur court fees because they have to be first filing the case in court. It has to be a registered court case, and by that time, legal fees may be incurred because they may engage a lawyer to file the case in court. So yeah, so these are the major three differences that I can identify, and I must stress that this is a freedom of choice because the purpose of a court-annexed mediation is not in any way to undermine private mediation because they are equally important, because mediation is simply a peacemaking process and anyone is capable of doing that. However, the difference is that it depends on the need of the expertise of your specific dispute. Yeah.
So, Dr. Melissa, just to go on further from what you have just mentioned, what would you call, would you consider it court-annexed mediation if a case that was referred to in the lower courts, for example, was recommended for mediation by private mediators? Because this has been the experience for us in Sabah in the past, where cases have been referred to for private mediation. Would that still be considered a court-annexed mediation, or would that fall within the realm of private mediation?
In my opinion, I think that is if the case has been referred to a private mediation, that would not be called as a court-annexed mediation.
Okay. So
Yeah.
court-annexed mediation is if the mediator itself is a judicial officer.
All judges, all active judges.
Or active judges.
Yeah.
Okay. And so what are the roles for lawyers in a court-annexed mediation?
Okay, what are the roles for the lawyers? I have identified 4, and it comes with the acronyms A, B, C, D. First, advisors. Lawyers support the clients, but I must stress this, their advisory roles are very minimal. They do not participate in the negotiation process, but rather explain the available options to clients, helping identify differences and common ground between parties. If the mediation is successful, lawyers will assist to draft a settlement order and present it before the judge. B, bridge builder. Lawyers act as peacemakers, building bridges between disputing parties by encouraging exploration of settlement options. Effective bridge building involves identifying common grounds and understanding the underlying issues between the disputes, requiring patience and persistence, possibly spanning multiple sessions of mediation. I used to tell the lawyers in mediation sessions that we are the bridge builders, not the bridge burners. We aim to identify and diagnose the reasons for dispute, whether they stem from grudges or unresolved issues, which we address during the sessions. C, collaborator. Lawyers collaborate with mediators and judges. Collaborative efforts with lawyers enhance the success of mediation. Reluctance to collaborate can create barriers between the parties, where proactive collaboration facilitates smoother mediation sessions. In my experience, I usually have a meeting with the lawyer first to iron out issues and to take this opportunity to get to know the parties a bit better, because I believe as the clients come and seek advice from the lawyers would understand the client a bit more than me, rather than me seeing them the first time. So get whatever that I need from the lawyers. If we have collaborative lawyers, the chance of success is higher. Speaking from experience, I have had cases where lawyers were reluctant to collaborate with me, making it difficult to break the invisible wall between the parties. The parties felt they were forced to attend the session. On the other hand, I have encountered cases where lawyers proactively did all they could to help the clients to explore the options. The dynamic can be very different. The parties who have full support of the lawyers in the mediation process will contribute to the smooth sailing of the mediation. In a mediation, from my experience, after meeting the lawyers, the mediation will usually be divided into a few sessions. First, I'll meet the parties together in a joint session with the lawyers and explain the agenda of the mediation and to get consent to be the mediator, a formal consent. And then I would have a private session. Usually it would be without the presence of the lawyers. Then after that, I'll have a joint session and see where the dynamic goes. There are certain times where it comes to complex cases, especially in construction matters, where I had the opportunity to mediate. At the end of the day, they allowed the lawyers to join in just to look at the accounts, certain accounts that not balanced and take into consideration of the accountant's reports and all that. And because of that expertise, the case is settled. And it's a very complex, otherwise it would be very complex and lengthy trial just to go through the accounts. So imagine that, with that case, with that experience actually allows me to, actually it opens my eyes through that experience, that successful mediation, because it proves that, we, the court, can actually also mediate complex cases. But of course, with the cooperation from the lawyers. And D, the last one that I can identify, the roles of the lawyers is discourage litigation. I can do no better than to quote this from a famous statesman, Abraham Lincoln. Discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the minimal winner is often a real loser in fees, expenses, and waste of time. As the peacemaker, the lawyer has the superior opportunity of being a good man. There will always still be business enough. So discourage litigation whenever the risk of the trial is greater than the reward. No client wants to spend money on taking a case to trial where the risk is greater than the reward. Therefore, it is your duty as lawyers to examine and explain the risk fully so that your client can weigh the options. It can be in the form of a compromise or an amicable settlement. So in summary, the rules outlined above that are A, B, C, D can be encapsulated in the word peacemaker. Lawyers' participation in peacemaking process is integral to the administration of justice. For these questions, allow me to conclude with this poem. Justice is more than the letters of law. It is the balm for wounds where healings draw. To reconcile bridges, to mend a strife. In the administration of justice, let there be light. Thank you.
Well, that's a wonderful poem, and I think you've outlined the role of the lawyers very clearly. But I do want to pick on something you said earlier, that you have encountered in your experience lawyers were less than collaborative or less than supportive of the process of mediation. And if I were to put on my cynical hat, I think lawyers earn more supporting their client through litigation than supporting their client through mediation, in which settlement is easily or more easily reached and in a shorter time. So in the face of self-interests, how do you propose we can encourage better collaboration among lawyers? What do you think would be some of the key factors to encourage better participation, better collaboration among lawyers in court-annexed mediations?
First, as mediators, we have to study the files. And perhaps, as I said, I would have the first meeting with the lawyers. And I would say that, the first thing that I would encourage the lawyers is that, to identify the needs of the parties. So yeah, and yes, it's not all the time we succeed, because as you mentioned, self-interest comes first, and we can't blame the lawyers. So but at the end of the day, it is really sometimes, if I can't do it, I'll do it through the clients. So I'll do it through the clients.
I would absolutely blame the lawyers. I would totally blame the lawyers if they actively sabotage a mediation session for self-interest. Yeah. And I have, as a mediator myself, I have seen firsthand these particular experiences. So so it totally resonates with me what you're saying. But I would be curious to know, how do you overcome that?
So I overcome that. I think once or twice I overcome that by speaking to the client in the absence of the lawyers.
Private session.
Private session, yes. Without the lawyers and truly, as I use the word diagnosis, we, as mediators, we become the ad hoc doctors to diagnose the problem. Why do you want to file this case in the first place? Or why do you want to defend your case this way in the first place? If we can't decide on anything, can we come to a common ground? Then later I would discover to say that, oh, actually, the parties have a common ground. So with that, I would bring that to the lawyer. Say, do you know that both parties have this common ground?
So
I would say,
have you ever failed at rallying the lawyers to the side of mediation?
both. I would say I have both experience. I have felt sometimes, and I have succeeded in some ways. Yeah. So if I can't do it with the lawyers, I would do my very best to try to talk through things with the clients and to see how things go. Yeah. So that is my only. Perhaps Datuk Vernon can give some ideas as well, or maybe Rajesh, you can give some ideas as how your experience is. I think we all experience the Young Arif and Arif here, or all the registrars or magistrates or court officers who attended this talk. I'm sure that we all experience the same thing. We don't have a lot of collaborative lawyers. Hence, my D, the last role of a lawyer is very important. I can't do better than the traditional quote of Abraham Lincoln. There will still be business enough.
Yes, that's certainly something interesting to ponder. I was thinking as well, in what circumstances should cases be referred to court-annexed mediation? I would say that not all cases should be litigated, but can all cases be mediated?
Not all, but I would say at least, I do have one or two cases that we could not have successful mediation as they come up to a settlement. But what we could do through the mediation is to iron out issues to be tried. So instead of going through thousands and tons of unnecessary issues, and through mediations, we identify some common grounds, and then we left one or two, said that, oh yeah, this is something that, parties still can't do it. Then we go to trial just on this one or two issues. Yeah, so that is something that I would say, something that we can achieve as well. So not all cases should go for litigation. Yes, I believe, because especially matrimonial cases. Yeah, because we don't encourage the parties to wash their dirty laundry in public. And especially family disputes. When I talk about family disputes, can be very complex because it comes from grudges more than 40 years ago, or 10, 60 years ago. So things like that, at the end, but going through mediation for that type of cases is taxing. But then at the end of the day, we also have to be the mediator. What actually keeps the mediator going is the purpose of that mediation is just so that the best interest of the parties, so that they won't wash the dirty laundry in public and they leave a good legacy. In matrimonial cases, it's for the children. So I used to tell in matrimonial cases, I have a lot of matrimonial cases that come from mediation, especially the custody of children and things like that. So what I would normally encourage the parties is really to think out of the best interest of the children and not themselves. So these are some speaking of from my experience.
So I know you're speaking from the perspective not just as a judicial officer, but as a mediator who's been trained. Now, as a mediator and a mediator trainer myself, I am well cognizant of the fact that mediation requires a special skill set. You may want the best interests of the parties all the time, but you are required to have a special skill sets to manage the process of mediation effectively. And success and failure could really depend on whether or not you have an effective and skilled mediator. So based on this, is it your opinion that for court-annexed mediations, judicial officers and judges should go through a course of some sort that would help them acquire these skills?
Yes, you are very right. I think, if I'm not mistaken, Datuk Vernon can, perhaps can have a view on this. If I'm not mistaken, all the mediators, before we come to the the pool of mediators, we have to get accreditation. We have to go through trainings and pass the, I think it's a course for mediation before we can be part of the pool of mediators.
All judges and judicial officers have to pass a mediation course?
Yes, yes. Like for myself, I went through the course first before I became one of the mediators.
Okay, interesting.
Yeah, but I'm
Okay.
not sure now. Yeah, so that's why I said Datuk Vernon, because as the head of the chairman of mediator, perhaps Datuk Vernon can
That
give
would
some
be a
insight
question for
on that.
Datuk Vernon then, for sure.
Yes, yes.
Yeah, so I want to thank you for what you have just said. I think it's given us a lot of things to think about, and I'll certainly come back to you with any questions. But let me move on to Datuk Vernon right now. Well, Datuk Vernon, we've talked a lot with Dr. Melissa about the qualification of specific judges and judicial officers in the area of mediation. Is it necessary? Is it mandatory for them to go through a course to acquire these skills in order to become effective at their role or not? So is this something that you can comment on?
Yes, I think training would definitely help judges to become better and more effective mediators. I myself, I am a backdoor mediator. I have no training. I have no accreditation, self-taught, reading books, trial and error, but more importantly, the passion to mediate and to help parties. But strip of all that, I think it's necessary as a prerequisite for any mediator, whether a private or a judge or judicial officer in court-annexed mediation, to undergo some basic training in mediation. And that such skills are essential and important because we are dealing with parties. When you talk to them, a lot of confidential information comes in during the process. And there's, of course, the delicacy of dealing with parties in a course of mediation. So the answer is yes.
You think it would definitely benefit them, but at the moment, it's not a mandatory thing?
Well, when I was a sitting judge, we had programs for superior court judges on mediation conducted by trainers. And then we have had in-house sessions for newly appointed judicial commissioners on the basics of mediation as well. So that's just a start.
It's encouraged, but it's not mandatory, I guess.
No, it's not mandatory. No.
I think I can speak from my experience though, as a mediation trainer. The country of Fiji, for example, when we spent 5 years training the bar and bench in Fiji, that all of them went through mandatory training to acquire mediation skills so that there would be a push towards mediation in the country of Fiji. So that's an example of a mandatory training program that another country has adopted. Would you say that this is something that we should explore in terms of a direction for the judiciary?
Yes and no. I don't think it's really for me to say anything. But I suppose insofar as judicial officers are concerned, the Sessions Court judges, magistrates, and the registrars, they are all trained or accredited mediators. So that's not an issue.
This is what I want to say. Yes, that's right, Datuk.
That's right.
Yeah.
So the only issue is with High Court judges, because not all of them are accredited mediators, but they do it on a voluntary basis. And I think they're doing a good job so far.
Okay, excellent. So we have heard from Dr. Melissa that mediation there's a lot of good in it to help reduce certain aspects of a matter before going to court and things like that. And one would imagine that it would also reduce backlog for cases whenever a matter has been mediated, you know. So if not all cases go for litigation, it automatically reduces the backlog. So apart from reducing the backlog of cases, were there any other reasons for the introduction of court-annexed mediation?
Right. Now, court-annexed mediation was introduced around 2010, 2011. As a precursor to the introduction, we had two Court of Appeal judges from America who came to give us talks, lectures on mediation and how effective mediation is and was in taking the majority of cases outside of the court docket. And they said that mediation was so effective that it enabled them to clear up to 90% of their cases in the docket.
90%?
Yes. And they only have to hear 10%. So I was not convinced when I attended the talk. I thought that was impossible. But those are facts staring at you, so you can't run away from facts. So once we were convinced that mediation was a pathway to the reduction of backlog of cases, we decided to embark on it. And the backlog refers to old cases that had accumulated over the past 10, 20 years, and new backlog cases that cannot be cleared within the timeline, which will add to the existing backlog of old cases. So there are two types of backlog, old cases and new cases. So the other reason for the introduction of court-annexed mediation was because mediation as a form of dispute resolution was practically unknown in Malaysia. Even though the Bar Council had launched their Malaysian Mediation Center in 1990, but from 1990 to 2010 and 2011, practically there were no takers for mediation. So we felt that it had to be, in order to make mediation a real choice for parties, it has to be top-down, which means we have to do it from the courts, bring it down to get lawyers to learn about mediation, to try mediation, to advise the clients to go for mediation, and then to see how the culture of mediation takes root from there. So just a very simple example. When I started to do mediation in Johor Bahru High Court, after attending the talks by the two Court of Appeal judges from the US, and I invited the lawyers to bring their clients in for mediation, the lawyers were hesitant. They were not sure how mediation worked. They were skeptical that mediation would work, and they thought that it would affect their livelihood in terms of, as litigation lawyers, it will make them irrelevant.
Yes.
But as judges, when you request for parties to come, lawyers usually say, all right, they will accede, they won't say no. And when we started to have mediation sessions, the success of case that we have managed to achieve in the first 6 months from the very beginning started to make an impression upon lawyers, so much so that they all, after that, were quite happy whenever we suggested that the matter go for mediation before a judge. So mediation will have its takers once lawyers are exposed to it.
Okay. Definitely, this is something that we can think about. But besides reducing the backlog, how other ways can we use mediation to improve the outcome for parties in particular?
It depends on the type of cases. Of course, the type of family matters are most suitable for mediation. And then you have got landlord-tenant matters, contractual matters, joint venture, things like that, where there's an existing relationship between the parties. Those cases are most suitable for mediation. So if you can identify a type of cases that are suitable for mediation, like even defamation, very suitable for mediation. So those type of cases should be the first target group of cases that should go for mediation, even before they go to court.
Yeah. So I think one of the issues that people have with mediation is that because it is voluntary, very often I find a case that one party wants to mediate, but the other party doesn't want to mediate. And so the whole case doesn't go for mediation at the end of the day. Is there any way to overcome something like this? Or is that a different case for court-annexed mediation?
So I suppose you are asking really, why is mediation not popular?
Yeah.
Okay.
Why is it not well known?
Yeah. Well, just take the Malaysian Mediation Center, established 1990. By 2017, they have only registered 255 cases over 20 years, almost 20 years. And you're talking about 20 years, you will have only registered 255 cases. It shows there's practically no take-up of private mediation by MMC. And of course, you have got the panel of accredited mediators in MMC. But as of today, I've checked, it's only about 300 or so accredited mediators. Now, really, you ask me, is it enough for Malaysia to have only 300 mediators? No. You need to have mediators in every station of every court district, so that when mediation takes root, they are really mediators to provide the services as a mediator. And then, but sadly, the lawyers themselves are very reluctant to refer clients to mediation because they feel that mediation is ineffective, it's time-consuming, it's a waste of time, and it makes them irrelevant as litigation lawyers. So therefore, it's important for lawyers to be made aware of how important mediation can be as a pathway to dispute resolution, how good and beneficial it is for their clients if the matters is settled in mediation, and how much, and that the services that they provide to their clients as mediation advocates for their clients is as important and valued as if they are litigation lawyers as well.
Okay. Well, following your comments, what steps should be taken in order to make mediation the preferred choice for disputes?
Well, number one, mediation should be mandatory.
Mandatory?
Yes.
Well, I have to agree.
It should be mandatory in the form of a pre-action protocol, which means that before you file a suit in court, go for mediation first. This has happened in a few countries, Singapore, Australia, UK, US.
Private mediation?
Yes, private
Private
mediation.
mediation? Okay.
Yes. So these cases that go out for private mediation do not end up in court. For example, defamation matters in Singapore must go through private mediation. Running down cases must go through mediation. This is within the state court system. Landlord-tenant matters must go for mediation. Now, even in the UK, matters coming under the purview of judicial review, some of those matters will have to go for mediation first before they can file the action. So you need a multi-pronged approach. One is pre-action protocols must be in place to compel parties to go for mediation before they can file the action in court. So if the mediation fails, then they can go to court. Then number two, mediation must be made a core subject in law schools and at the bar council induction program for the new lawyers. It must be a core subject. Then number three, mediation is not about mediators. Mediation is also about mediation advocacy. Lawyers are not trained about how to conduct themselves as mediation advocates. They come to a mediation session, they start arguing like they're in court. They want to impress the mediator about the merits of their client's case. But then again, mediators don't decide. We only help the parties to settle. At the end of the day, I think we have to recognize that mediation is about, technically it's called a form of facilitated negotiation. But I would prefer to call it healing relationships. Once you heal relationships, you bridge the communication between the parties. Then once there's communication, you have a 50% chance of getting the parties to settle the matter. So BICAM, in selecting this subject for today's BicTok, this will play a pivotal role in promoting mediation in Borneo.
Mm.
It can be the springboard for mediation by getting more lawyers involved to be mediation advocates, to equip them with a skill set as mediation advocates, getting more lawyers to become mediators, so that the hardware is there. So when the take-up starts increasing, the hardware in the form of mediators and mediation advocates will be able to provide the service and enable the growth of mediation in Borneo, especially private mediation.
Yes,
I think more importantly, lawyers must remember mediation has always been undervalued as a service. So they think their fees do not commensurate with that of litigation, but not necessarily. At a recent workshop I attended, where a Singapore mediators shared some information, they were so happy to announce that they managed to settle a case involving a few million Sing dollars through mediation. And I think that demonstrates the fact that no matter how contentious a matter is, no matter how high the subject value of the mediation is, matters can still be resolved in mediation. So as a skeptic, I'm now a proponent of mediation. Thank you.
Thank you very much for your comments, for your input. There is actually, I want to reiterate the fact what you had just said. There is actually there should be no ceiling, prescribed ceiling for the disputed amount that can be resolved through mediation. It is about skills. It is about the willingness of the parties to come to the table and resolve something. And it doesn't matter if it is something that is 5,000 ringgit or 500 million ringgit. The same principles apply when it comes to settling or facilitating a particular mediation. So I wholeheartedly agree with you there, Datuk. Thank you very much for your input. Let's move on to Ms. Rajeswari. So Rajeswari, as I was reading your CV, it seems you have tremendous amount of experience in industrial relations matters. So in your opinion, has mediation been effectively utilized in resolving industrial relations disputes in the country?
Well, my answer would be mainly yes, because I think the difference here between in industrial court or industrial disputes and civil cases is that there is an inbuilt mechanism in the act itself. So if we looked at the Industrial Relations Act 1967, which practically governs the main aspects of industrial relations in Malaysia, you find that there is where parties bring up a complaint against each other. Usually the parties in this case would be employee and employer, or trade unions of employees and trade unions of employers. When they bring up a matter, they will have to go through the Industrial Relations Department at first. And at the Industrial Relations Department, there is a compulsory conciliation process. Now, it is a mediation in effect, okay? And this mediation is undertaken by the relevant officers who handle these specific files. So there are many conciliators come mediators all around the country in the form of industrial relations officers. And they report to the Minister of Human Resources, in fact, through the Industrial Relations Department. So what they do is that they will call up the parties. And at that point in time, there is no representation. Lawyers aren't allowed to be present in these sessions. So they go there to the department, and at these offices, the officers actually try to get the parties to speak to each other and see how they can iron out the differences, what is the main points of contention, whether it can be resolved in that manner. most of the cases that comes to the industrial court are actually on unlawful dismissals, where the employee who has lost his employment, he or she claims that the termination was unjust. So when the employee will want to take up a case, they will have to go through this compulsory conciliation first. How successful is this? Okay, I would say it depends very much on the experience of the conciliators or the officers concerned. Usually, the longer the officers have served in this capacity, they become better at conciliating and getting parties to mediate the differences and disputes. Okay, I would say in terms of numbers, I would put down maybe 20%, 25% of cases actually get resolved at that stage itself. So cases
Only
then are,
20% of cases.
yes, I would say 2 in 10 cases get resolved at the department level itself. So that then brings, okay, so the rest of the cases are then brought to the Director General of Industrial Relations, or in some cases like the collective bargaining disputes and all, it goes to the minister and it will get automatically referred to the industrial court. Now, at the court itself, what happens is there will be several stages of case management before the case is set for trial. So at the case management stage, most of the time, the case management is handled by the assistant registrars of the industrial court. They will speak to the parties and encourage parties to resolve. Now, this is because the main objective of the Industrial Relations Act is to promote speedy resolution and to restore harmony between the parties. Simply because it is an employer-employee relationship or a dispute maybe between the unions, for example, and parties have to basically get back to business. And the sooner they get back to business, it's better for everyone all around, right? So this is why it is encouraged. And when this is proposed, then if both parties agree, or even if one party agrees, then the assistant registrar may then encourage the other party to participate because there is no risk. They can just, they are told that, why not we give this a try and so on. So then mediation is carried out by one of the chairmen, not necessarily the person who's going to handle the case per se or hear the case in the final ultimate trial of the matter, but anyone, okay? Sometimes parties themselves choose who they want to be the mediator in a case. So they have a pool of chairmen to choose from. And then once the case goes for mediation at that stage, I would say another 30% cases gets resolved at that point easily. So if you look at overall globally, the figures from maybe 10 cases that comes, okay, that are filed in the Industrial Relations Department, easily 50% cases gets resolved amicably without parties going through a litigation process, a trial process, through efforts of mediation done in the name of conciliation and other names like getting parties to sit down and arbitrating the issues between them. Okay, it's essentially mediation that happens there in the industrial court, okay, and the Industrial Relations Department. So if you ask me how effective it is, I say it's very effective. It has been helpful because I cannot imagine if all these cases were to end up for trial. As it is now, based on my experience from the date of the first case mentioned, right up to trial, sometimes cases take up to 24 months. Now, that is really, a situation that is not favoring anyone, simply because the longer the case goes on, the employer is exposed to greater compensation because the compensation is usually back wages in unlawful dismissal cases. And back wages tends to run according to the period, okay, the case takes to be resolved and disposed of. Of course, this is subject to a maximum compensation of 24 months of back wages, not counting, okay, compensation in lieu and others. But again, this is not favoring the employers. And as for employees, again, as long as they are tied up to an ongoing case in the industrial court, and sometimes the appeals of these cases take much longer, they often find it difficult to find another job and to move on. Hence, it is something that is in the interest of both parties, And imagine if this is a dispute between a trade union, for example, over a collective agreement, a collective bargaining dispute. Until the dispute is resolved, the union members, which encompasses a large group of workers in an establishment or a factory floor, for instance, they will not be able to get annual increment or salary adjustments until the collective bargaining dispute is resolved. And at times, by the time the case goes through the High Court, for instance, the Court of Appeal, or even Federal Court, they'll have to wait for years. And another 1 or 2 more rounds of collective bargaining, timelines would have come up and so on. So it's
in other
highly...
words, mediation is effective in resolving disputes and reducing timelines and reducing backlog, as you mentioned.
Correct.
So I'm curious as to which stage of an industrial relations dispute that mediation is likely to succeed. At what stage do you think it would be likely to succeed?
I think 2 milestones, I would say, two points I would mention is, one is the case management stage itself. You see, after the first mention, parties are given directions to file pleadings and so on. At that stage, if mediation is floated to the parties, or they are made aware that, this mediation, such a facility is available and it is free of charge, and it is for them to avail, the parties in dispute can avail themselves to this process without compromising or prejudicing their claim. They might be open to giving it a fair consideration, because see, when they would think deeply about it at that point in time, because that's the time when they will have to give instructions, documents, evidence is verified by the councils and so on. So that is the stage where the councils also have a good idea, of what is it that the fact in dispute, is, and how to prove their client's case and so on. So there will be a good stage. And second, I think if, let's say, that timeline is has passed or is missed, the other often, when the matter is still fresh, on the hearing date itself, the morning of the hearing, psychologically, parties come to court. They are, in a way, prepared. They come prepared, yes. But at the same time, they are also most receptive to settling a matter at that point in time, because they will know what's ahead of them, right? So a witness who has to give testimony, for example, the key witnesses, the officers of the company who are, collating or working with the councils themselves, they are most open at that point in time. I think these are 2 main time frames I would actually point out from my experiences.
Well, that's very illuminating. And I think there will be a lot of questions from our audience members for our 3 speakers. You have the option, participants, you can unmute yourself and ask your question directly, or you can type in the chat box and we can go from there. I have a particular question coming in through the chat box directed to me right now, and this one is for Datuk Vernon. Besides self-training, are there any training programs within the judiciary for mediation? Would the judiciary be open to have the program, for example, in collaboration with BICAM? Is this something that you can foresee happening?
Well, I'm really retired from the bench, so I don't think I can comment. Maybe we can grab hold of Datuk Lim Chong Fong, who is the chairman of the Court-Annexed Mediation Committee. He's with us today.
Oh, is Datuk Lim Chong Fong in the audience today?
Yes, he is.
Hello, Datuk Lim, how are you?
I'm fine, thank you.
Good to see you again. Well, so the question now is, besides self-training, are there any training programs within the judiciary for mediation? Would the judiciary be open to have such a program in collaboration with BICAM? Is that something that you can see happening?
Yes, why not? I've actually just assumed office not so long ago. So we are now mapping out the more detailed programs for this year and perhaps next year too. So yes, we are looking into training. We have not finalized anything as yet. This is just 2nd month of the year. And yes, again, why not with BICAM, especially maybe for the East Malaysian judges. Or even you can incorporate the West now.
No, I would like to say for BICAM that East Malaysian trainers in BICAM can also fly to West Malaysia to conduct training. It's not a problem at all. Geographical issues are non-issues for us. So I'm happy to hear that you are at least open to collaborative programs with BICAM. Are there any
Yes, we will
questions?
certainly look into it.
Great, fantastic. Are there any questions from the floor? Anyone who would like to chime in? Oh, I see. I have a question from Amanda. Can only a Sabahan become a mediator in Sabah? So I can invite anybody else on the panel to answer this question, but I think the answer is quite obvious. Melissa, would you like to jump in? The question was, can only a Sabahan become a mediator?
No, certainly not. Because I believe I have even for court-annexed mediation as well. We have non-Sabahans officers here who are mediators. So yeah, I think at the end of the day, it's not because of because of your stateship. So at the end, yeah. So long as you have a dispute here, and this is something that if your expertise is needed, why not? And I believe, I think these questions, perhaps, I think he's referring to BICAM, right? The mediator for BICAM. So perhaps, I see that Tan Sri David Wong is here. Perhaps he can give some insight. So any non-Sabahans can be here to be a mediator for BICAM. So Tan Sri, we can't hear you. Tan Sri David.
Okay. Can you hear me now?
Yes. I think this is the question. Perhaps this is the. I think this is what the question means.
So everyone can hear me now?
Yes.
Oh, okay. Firstly, greetings to all my former colleagues on the bench. Great that you guys are supporting us. Chong Fong, Penang, Anand, and former Federal Court Judge Vernon. How are you, Vernon?
Good,
And
thank you.
all the other people who are supporting us, I'm very glad to see that we have so much support. Of course, you actually BICAM is actually opened an opportunity to everyone in Malaysia for the world. If you register as a BICAM mediator, and if the mediation is done under the auspices of BICAM, you can come in. You can come in. There's no prohibition from you coming in, and so the answer is no. In fact, myself, as you know, I'm a Sabahan, and I've been doing a lot of mediation for West Malaysians over there. Actually, I'm in a panel of mediators with Cedric, the security industry area where people complain about banks and all that. So no, by all means, you are actually BICAM. You can say is the borderless institution.
Well, thank you very much, Tan Sri. I see that we are coming to the end of our time here. If you have any other questions, and you send it to us in the chat group, we'll do our best to forward the answers to you even after the session. But before we end the session, I just want to express my heartfelt gratitude to the speakers for today, Dr. Melissa, Datuk Vernon, and Ms. Rajeswari, for your input and for your expertise in this area of court-annexed mediation. And I would also like to invite Tan Sri David Wong, the chairman of BICAM, to say a few words to the audience.
Well, firstly, Justice Lee, I didn't see you there, so you're there, Justice. I just want to just express on behalf of BICAM for all the support that you guys has given us this afternoon. I think the numbers are quite encouraging for us, And for the speakers, thank you very much. Vernon, Melissa, and who else? Who else are speakers?
Rajeswari.
Yeah, thank you very much. And I hope Penang is not too far away from us, Anand. Thank you very much. We are the new kids in the block. Hopefully, we need your support. And again, I repeat, we are a borderless institution, be it mediation and arbitration. Okay. Thank you very much, and have a good evening.
Thank you.
Thank you all.
Thank you, Tan Sri. And I'd like to say have a good evening to all our participants. Thank you so much for participating in our event today. And please watch this space and look out for our next event. We will continually have BicTok talks online and hopefully live sessions as well. So if you follow our page and our social media, you can be the first to be informed of all these events. Thank you, everyone. Have a good evening.
Good evening. Bye.
Thank
Bye.
you.
Bye.
Anand,
Yeah, yes, Tan Sri.
give my best to our mutual friend, Kenneth.
I will. We're all in Langkawi this whole weekend for Judges Conference. I'll see you there.
Another privileged weekend. Okay.
Something like that.
See you guys. Bye.
Okay, thank you, Tan Sri. See you.
Okay, see you.
Bye.